Now resume, and I call officers from the Fair Work Commission, including its General Manager, Mr Murray Furlong. Sorry about the fright we gave you before the break, but glad to see you all here now. Mr Furlong, did you have an opening statement for us?
Good evening, Chair. No, thank you.
Okay, excellent. In that case, we'll move straight into questions from senators. I'll start the call with Senator Roberts, and then I'll come to you, Senator Kovacic.
Thank you, Chair. Thank you for appearing again. Good to see you, Mr Furlong.
You too, Senator.
I have a series of questions for understanding the relationship between awards and Fair Work Commission endorsed and authorised enterprise agreements. Does the Fair Work Commission have a requirement to ensure that pay rates under enterprise agreements are at minimum the same as or higher than pay rates under the appropriate competitive award? So I'll just be specific. If an award requires, say, a cleaner to be paid $30 an hour as a full-time employee, could the Fair Work Commission endorse or authorise an enterprise agreement that paid the same cleaner, say, $25 an hour as a full-time employee?
As we've traversed several times before, Senator, if an application is made to the Commission to approve an enterprise agreement, the Fair Work Act requires the Commission to approve the agreement if it is satisfied that the requirements in sections 186 and 187 of the Fair Work Act have been met. This includes a requirement that the agreement passes the Better Off Overall test. In terms
passes
of
which test?
The Better Off Overall test.
Food test, yep.
Yeah. In terms of the minimum rate of pay, the agreement cannot provide less than the rate of pay, the base rate of pay in the applicable award. But in terms of penalty rates, it's a holistic view of it. It won't be a case by case basis. It won't be a line by line analysis.
So an enterprise agreement could not pay less than, if it's just a straight enterprise agreement, doesn't roll overtime in and everything else, it could not pay less than the award rate.
Well, in terms of the minimum rate of pay,
yes.
Yes.
Thank you. Okay. There are no tricks in here. I'm just trying to learn. Okay. Do you agree that when calculating a full-time employee rate and adding all entitlements, holidays, etc., allowances, that generally you would add around 19% of the full-time rate?
I can't comment on that, Senator. It's members of the independent statutory office holders, members of the tribunal, who apply the Better Off Overall test and ultimately what they consider and ultimately approve enterprise agreements. I can't talk about what they, in terms of the legislation or the legislative scheme provides the things that they need to consider before approving an enterprise agreement, but it is a case-by-case basis.
So by adding, say, taking that cleaner again on $30 an hour, by adding entitlements of 19% to the effective pay rate, benefit would be around $35.70. So if it's not 19%, what percentage would they use?
I think that what they would do is look at the underpinning modern award and then consider that in the whilst they're considering the enterprise agreements in front of them for approval, and then they'll make a determination based on the on those two documents and on the case law, the relevant case law, whether or not it satisfies the Better Off Overall test and the other pre-approval provisions. And on that basis, a member will make a determination if the agreement should be approved and whether or not the agreement should be approved with undertakings.
So there wouldn't be any requirement to pay the cleaner at least, the casual cleaner, at least the award rate plus 19%. There wouldn't be any hard and fast requirement. There's
no hard and fast requirement that, and I understand where we're sort of heading to here. If a modern award does not contain a casual rate of pay, then it doesn't preclude an enterprise agreement containing casual rates of pay.
Say that again.
If the underpinning modern award does not prescribe a casual rate of pay, that does not preclude an enterprise agreement being approved that does contain a casual rate of pay.
How do you think the Fair Work the Fair Work Commission would assess whether or not the enterprise agreement was not paying less than the award if it was a casual?
In the approval decisions, the members outline their reasons for approving or dismissing applications for enterprise agreements. So in relation to the Chandler McLeod agreements that I think that we're referring to here, I think it was...
I'm referring to a lot of them, but
yes,
keep going.
Okay. Thank you. The members, including the Senior Deputy President who approved a number of these agreements, outlined the reasons for her decision to approve those instruments, those enterprise agreements at the time. Now, so I can provide copies of those decisions on notice if that would be of assistance.
That would be of assistance. So the Fair Work Commission, or the member as you call them, so long as she has valid reasons and lays them out in writing, or he, they could approve a casual rate of pay less than the award rate of pay. For the less than a permanent employee rate of pay in the award, a casual rate for a casual could be less than that.
I can't talk to the decisions of members of the Commission. Those decisions stand for themselves, Senator. And whilst I'm trying as hard as I can to be helpful, the decisions of members to approve enterprise agreement, they rest with the member who makes the decision, and obviously the reasons for approving or, as I said, dismissing those applications are outlined in the decisions. Right.
So long as the decisions are justified, that's it?
No. Well, there's appeal rights. There's appeal rights. So if an enterprise agreement has been approved and there is an aggrieved party who has standing to have that decision reviewed, then they can certainly do that, and they will be reviewed by a full bench of the Commission. Okay. But ultimately, and at the end of if an agreement is past its nominal expiry date, they continue to operate until they're replaced or repealed. Then a party or a person who's covered by that enterprise agreement can make an application to the Commission for that industrial instrument to be terminated, at which point they will return to the terms and conditions of the underpinning award.
But excuse me, we'll get to an appeal later, but just for now, an appeal requires going to the court.
In the first instance, it will come back. The appeal will be made to the Fair Work Commission, and then it will be dealt with by a full bench of the Fair Work Commission.
Yeah. So
they'll be constituted generally by 3 members.
Okay. So next question: are you aware of Fair Work Commission endorsed or authorised enterprise agreements that pay employees A, below the base award full-time rate, or B, below the base full-time rate plus entitlements, or below the casual award rate?
I'm not personally aware of instances that are occurring. We approve somewhere between 4,000 and 4,500 enterprise agreements a year, and the process for approving enterprise agreements is the application is made, they are then reviewed by an expert team, specialist team who hold skills and specialist sort of knowledge around the assessment of enterprise agreements. They complete a checklist, and then they will give that checklist and other supporting documentation to the member, and a member will then, with all of that information available to them, will then do a number of things. The agreement will, as made, will appear on our website. So if there's no to invite contradictors. So if there's another party or someone that has reason to believe that the agreement shouldn't be made, then there is an opportunity for that to occur, and that does occur regularly, particularly when there's demarcation issues associated with particular registered organisations, trade unions. But a member could receive submissions or information through that process. They could seek further information from the parties, or they could deal with it on the papers, or they could call the matter on for a hearing if it was particularly complex.
Okay, thank you. If an employer and a union came to the Fair Work Commission with a proposed enterprise agreement that paid below any of the scenarios I've just outlined, is it incumbent on the Fair Work Commission to undertake an independent analysis to ensure that the enterprise agreement rates are above the relevant award? or does the Fair Work Commission, or can the Fair Work Commission just endorse the enterprise agreement on the basis that the union and employer agree to the underpayment?
The member needs to be satisfied that each of the requirements under the Fair Work Act have been met.
So
they can do it, to speak plainly, they can do it on the papers if they are satisfied that the information that they have in front of them and the agreement has been supported or endorsed, for want of a better word, by a trade union, then that will obviously carry some weight in their determination about whether or not the agreement should be approved.
I can understand it would. Can I take you to the example of the enterprise agreement between the Shop Workers Union and Coles, excuse me, which was overturned in 2017 after the efforts of lone employee Penny Vickers? Familiar? That enterprise agreement had been endorsed or authorised by the Fair Work Commission and paid Coles employees below requirements. In the face of the employer and union, I'll use the term collusion, certainly agreement, it was efforts of a lone employee, Penny Vickers, against the might of the legal teams of the union and the employer that protected employee rights. One person. So my question is, where a Fair Work Commission authorised endorsed enterprise agreement pays below award rates and both the employer and union have cooperated or colluded on the underpayments, who has the capacity to challenge this? Is it only lone employees, or can someone else, for example like me, mount a challenge to the Fair Work Commission?
That's a very good example, Senator, of when an application is brought by someone who was covered by that enterprise agreement. They brought that application post, I think I'll have to take that on notice. It's been a while since I've actually looked at that case, the specifics of that case. It's a person, I'll have to take on notice who has standing to make an application to terminate an enterprise agreement. It's certainly someone who's covered by the agreement, or an employer organisation that has representational rights for that employee as well.
So I might not have representational rights if I want to if I want to intervene.
I haven't looked at this section of the Act for quite some time, so I'm not too sure who has stand. Is anyone else at the table on this? Might have to take it on notice.
Okay, thank you. Two more questions, Chair.
Sure.
If the Fair Work Commission authorised or endorsed an enterprise agreement that paid employees less than award rates, could this arguably be a case of the Fair Work Commission engaging in maladministration or some other error of law? Are there processes within the structure of the Fair Work Commission that such a review of underpaying enterprise agreements can be undertaken?
Do you mind if you just repeat the first part of the question, please?
If the Fair Work Commission authorised or endorsed an enterprise agreement that paid employees less than award rates, could this arguably be a case of the Fair Work Commission engaging in maladministration or some other error of law? And are there processes within the structure of the Fair Work Commission that such a review of underpaying enterprise agreements can be undertaken?
Just return to my early evidence that if someone believes that a decision of the agreement is a decision of the Commission has been made in error, then there are those appeal rights, and they should exercise those rights. Would it arguably be a case, if Fair Work Commission overturned its original ruling, would it arguably be a case of the Fair Work Commission in the first ruling engaging in maladministration? I can't. The independent statutory office holders exercising powers provided to them under the Fair Work Act. It doesn't relate to the administration of public servants. So I just want to return you to my evidence that the correct mechanism for dealing with this would be through an application for the agreement approval decision to be reviewed and overturned. Right. If it was found that the Fair Work Commission didn't apply the right, didn't consider the right factors in approving or authorising the enterprise agreement, would that be maladministration? Do you mind if I take that question on notice, please, Senator?
Yeah, sure. Yeah. Thank you. Last question. You are aware of my interest in black coal miners and the One Nation report that sets out in forensic detail how casual mine employees are underpaid in comparison to the award. I assume you're aware that the Fair Work Ombudsman is investigating the underpayments.
Yes.
You're aware of that. If the Fair Work Ombudsman were to conclude that coal miners have been and are being underpaid in comparison to the award, are there processes whereby such underpayments could be stopped and historical underpayments could be addressed by the Fair Work Commission with a view to compensating coal employees for the underpayments they suffered?
My understanding of the evidence that's provided by the Fair Work Ombudsman earlier this evening is that the reference instrument that they're relying on for their calculations to determine if there's been an underpayment is the enterprise agreement, not the underpinning award.
Yeah, but come back to my question. If they're being underpaid in comparison to the award, if that was found, if that was the reference document, then could the Fair Work Commission address that by compensating coal miners?
I think that the relevant... I'm not aware of the Fair Work Ombudsman actually doing the calculations against the award, because that's not the industrial instrument that applies to the employment of these coal miners, the casual coal miners that you're referring to. So my understanding, I obviously can't speak on behalf of the Ombudsman, I can only relay my understanding of their evidence from earlier this evening, is that the assessment won't be against the MOD award, it will be against the enterprise agreement that was approved, or the enterprise agreements that were approved at whatever point in time.
Okay, thank you very much. Thanks, Chair.
Thanks, Senator Roberts. Just for my list, is that the end of your questions for the Commission? Great. I'm coming to the opposition now. I've got an eager beaver in Senator Mackenzie. Senator Mackenzie, you have the call.
Great to see you all. Just following my theme of the day, as a good shadow transport minister, on Tuesday the 7th of October at the Rural and Regional Transport Senate Committee, Deputy Secretary of the Department, Ms Hall, gave evidence that Minister Rishworth had written to the Fair Work Commissioner regarding a minimum of 3 projects that are publicly funded infrastructure projects that have concerns with criminality and corruption. Is that correct?
Oh, that's for me?
To the Commission. I don't think they wrote to you,
No.
Mr Walsh.
I've received correspondence from Minister Rishworth about concerns that have been reported in the media about conduct associated with the CFMU Construction General Division. I responded to...
So when did you receive that letter?
I'll be able to... It was in early August. We have to get you the date. I responded on the 19th of August.
19th of August. Yeah. So given... That's fascinating. Ms Hall, if you're listening, Deputy Secretary, because of the 3 projects we discussed at estimate, some of them hadn't actually been reported to Minister King.
I think we might be talking at cross purposes here.
Okay.
You asked a question about whether or not Minister Rishworth had written to me in relation to concerns around the Construction General Division of the CFMU. My response was yes, and I received that correspondence. That was following media reports about alleged conduct that was still
So
occurring.
have you received a letter from Minister Rishworth on concerns about Centenary Bridge?
Not about those specific 3 projects.
Have you received a letter from Minister Rishworth on North East Link?
No.
Project? Only the Sydney Metro?
No. Sorry, Senator.
Yeah, let's
what I'm
be
saying
really
is
clear
that
which
not
projects.
specifically about those projects, about general concerns about the persistent conduct that we're all aware of in the building and construction industry.
So the evidence, and
Could I assist you, Chris Enright? I think the record was corrected where the information you're talking about was directed to the Fair Work Ombudsman and not directly to the Fair Work Commission, Senator.
Well, I referred them to the Fair Work Ombudsman myself, having found out this morning that no one had done that. So, thank you. Mr Enright, it's under control, but I'm just going to the evidence given by the department around what Minister Rishworth had done or hadn't. This morning I asked the department. She hadn't contacted her department. Minister King hadn't contacted the department. But Ms Hall's evidence is that Minister Rishworth had written to the Fair Work Committee. Oh, sorry, I can read. Bridget, put the glasses on. Minister Rishworth had written to the Fair Work Commissioner regarding a minimum of 3 projects, not in generalities, but your evidence is that it was a general letter around CFMEU involvement in publicly funded infrastructure projects.
I haven't reviewed the letters through that lens, and I don't have them in front of me now, but I've received 2 letters from the Minister following media reports about the persistent conduct in the building construction industry and requesting that I provide any assistance I can to the Administrator to ensure that that his efforts and that I do anything I can as the regulator of registered organisations to bring, as far as practical in terms of my own operational remit, bring the conduct in that industry back into lawful.
And so do you just want to run me through the actual projects that were raised?
I don't have those letters in front of me at the moment. We might be able to get them for you.
Yeah, if you could table them.
Yeah, and the 2 dates that the Minister wrote to me, the 22nd of July and the 10th of September.
10th of September, okay.
We should be able to find it. Get it.
So I would be requesting those letters be tabled. Has the Minister raised any specific projects with you or only generalities?
Not that I can recall.
Okay. And the Minister asked you to work with the Administrator?
Yes.
Specifically?
And
so talk me through what you've done since the 10th of September on the back of the Minister Rishworth's letter.
Well, in my response on the 19th of August, I outlined my operations or activities in relation to, as the regulator of registered organisations, but more broadly, what I have done is I initiated proceedings under Section 323 of the Registered Organisations Act last July to bring the Construction General Division into administration. We initiated or developed a whistleblower function that has received over 1,000, they're not allegations, they're pieces of information. Some of them relate to my regulatory responsibilities. A vast majority relate to the responsibilities of other regulators and law enforcement agencies. We've referred a significant number of pieces of information, allegations, alleged conduct to many regulators. We provided some detail on a question on notice, and the question on notice was SQ 25000020.
Yep.
And it goes to some detail about where the referrals are made and what they related to in a very broad
that
context.
19th of August letter was 2025?
2025, yes.
Yep.
In terms of other things that we've done, we have 3 current investigations that relate to conduct of previous officials of the division. We are active participants in the Joint Agency Working Group that's been constituted by the AFP. I am a member of an alliance, which is a Victorian government initiative to bring together regulators and other interested parties, including VIDA, to consider how we can best respond to the issues in the industry. I received 3 referrals from the Administrator, and we continue to work very closely with stakeholders across the industry. So in terms of what
in
have we
the 8
done,
weeks since you sent that letter, have you done anything additionally?
we've progressed the investigations that we've received. I've canvassed.
No new investigations, no new referrals?
No, we haven't initiated any new investigations since that time.
Okay, I will I have some more questions on notice.
Mr Enright probably has something else that he'd like. You can assist this.
Chris Enright, I'm the Executive Director of the Registered Organisation Services Branch, Senator. So just to assist Mr Furlong, one of the things that we have been doing is sharing information, high-level information with the Administrator about themes of issues being raised about construction and general division members in order to assist him, particularly in relation to allegations of breaches of internal policies and a range of things. So we've referred 71 different allegations and issues to the Administrator. We currently I have being processed another somewhere between 4 and 6 that I intend to continue to share, that I have on my desk or about to receive anyway. I've discussed it with staff. So we've over a period of time, I've written to the Administrator on 3 separate occasions this year, telling him what's going on in the industry, what's the sort of complaints that are being raised about members of CFMEU, so that he and his team can deal with them internally, and we continue to do that. And I propose to do that again through the authority of the General Manager over the next week or 2, Senator. So we're in constant contact, both as a regulator and trying to support the work of the Administrator.
Thank you so much. And unfortunately, the Administrator isn't with us, so we can't sort of get to the bottom of that. So I do appreciate that information. Has there been any? Has the Commission heard of, informally or formally, of concerns of the CFMEU behaviour with regional contractors on the Inland Rail project in Victoria?
I'll ask Mr Enright to assist.
Thank you.
As part of our, I'm not sure if specifically that, Senator, as part of the report of concern that Mr Furlong has already, the more than 1,000 concerns that have been raised with us, we have received information in relation to the North East Link project in Victoria, and we've made referrals to the AFP in relation, and the Fair Work Ombudsman in relation to that. We've also received information in relation to the Centenary Bridge project, Senator, and we've made referrals in relation to that. And we've also received referrals in relation to the Sydney West Rail Airport link in New South Wales, and we've made referrals in relation to that.
To the Ombudsman?
Yes, Senator.
Yes, I did that too. So we're in lock sync, Mr Enright. My question was around the Inland Rail project.
I'd have to take that on notice, Senator.
Yeah, could you?
Yeah.
There are concerns, and I'd like to know if somebody has concerns about the procurement processes, the behaviour of the CFMEU. Obviously, they don't have CFMEU EBA, they have regional EBAs for obvious reasons. I'd like to, where do they go? What is it, and is it confidential?
It would all depend on the nature of the allegation, Senator. What the General Manager...
Can you guarantee a regional contractor, if they've got an issue, is there a number they can call? There
are a range of... we've got a report of concern. The Ombudsman's got a similar type function. The Administrator himself has set up a whistleblower scheme within the Commission. And so one of the things that the General Manager did in July of last year was to set up this report of concern. Whilst the vast majority do not fall within his jurisdiction, we've been very, very keen to make sure through the Joint Agency Working Group that any report that comes through goes to the right agency to be investigated.
And you can guarantee confidentiality and no reprisal?
Well, we can't guarantee no reprisal, but what we can...
Well, you could if it was a confidential...
Well, we can
service.
We guarantee confidentiality when it's, for example, Senator, we won't. We've got on our report of concern form. If we ask a person to declare whether they will allow us to provide this information to anyone else. If they, and many of them say no, and if they don't, we simply protect their confidentiality. So we're very, very concerned about privacy and people's confidentiality.
Well, we do need to be with this particular registered organisation for obvious reasons. Thank you. I'll have some questions on notice.
Thank you, Senator Mackenzie. Senator Pocock, you have the call.
Thank you. Sorry, just coming to my questions. I've got a couple of questions. Earlier today, and thank you for being here. Good to see you again.
You too.
I asked Minister Watt and the Department of Employment and Workplace Relations about whether Labor has abandoned the 2022 election promised to, quote, work with state and federal governments, unions and industry to develop portable entitlements for annual leave, sick leave and long service leave. Minister Watt said this has an initiative that has been paused. That was his word. This is incredibly disappointing for those workers who do look to some portability for some forms of leave. Has the Commission done any work in relation to portable leave entitlements?
Not that I'm aware of, Senator. I'm just I'm thinking about the major cases and the research. As you're aware, the research we undertake to inform the full benches and the expert panels for those that are dealing with those major cases. I'm not aware of any research that has occurred that relates to portable entitlements.
So no research and no significant cases?
I'm not aware, but I'll take it on notice just so we can check with Senator.
Thank you. And I'm talking about portability of a range of forms of leave, obviously long service leave, which is available to some in the construction industry, but other forms of leave as well. Thank you. Okay, this could be very quick. My second line of questioning is in relation to the right to disconnect. On the 21st of August this year, the Fair Work Commission put out a statement at FWC FB-185 regarding the right to disconnect. You'll be familiar, I'm sure, with that statement. You've got it in front of you. It stated that while the modern award terms have now been in operation for 12 months, the Commission, quote, has not as yet considered any test cases or resolved any significant disputes in accordance with the terms. And you invited submissions into whether it was necessary to conduct a review of the model award term and whether you should make guidelines. How many submissions did you receive in relation to that?
I need to check to see if I have that information before me, Senator. Yes, as you mentioned, the submissions closed on the 3rd of October, but I don't have the number of submissions that we received, so I'll need to take that on notice. All the submissions that we receive are, of course, published on our website.
All of them are already published on your website?
Yes.
Did any of them recommend, to your knowledge, for the Commission to conduct a review?
I think, from memory, there is one submission which may have suggested a review, but I'll need to take that on notice.
Okay.
It may have suggested a review in relation to a particular award.
Okay.
But I'll take that on notice just to make sure I can give a full record.
And are we
of those
talking
submissions.
10 submissions, 50 submissions, 100, 6?
I'll need to take that on notice.
Right, yeah. Did any of them recommend that the Commission make guidelines?
I'll need to take that on notice.
Okay, thank you. I recall the former opposition leader saying that the right to disconnect would be, quote, damaging to employers and employees, and that the opposition would be repealing it very swiftly if they achieved government. Yet here we are a year later without any significant disputes. Is that a fair statement?
From the 26th of the 8th, 24, which is when the jurisdiction commenced, to the 30th of June 2025, we've received approximately 7 applications seeking to deal with a dispute or a stop order or a GP application about an employee right to disconnect.
Sorry, you said that so fast.
Seven applications.
Exactly what are they? They are applications.
To deal with a dispute.
Okay.
Stop order, yeah. Or a general protection application.
Can you summarise the outcomes from those 7?
I might ask
how they panned out
to assist with this.
Good evening, Senator. Chloe Eaton. I'm the Executive Director for Dispute Resolution and Support Services. Thank you. So in relation to the 7 applications that we've received from the 26th of August last year to the 30th of June, 2 were discontinued before the first listing, 3 were withdrawn, 1 dispute was resolved through member conference, and 1 matter is still ongoing.
So thinking about all the other many provisions and model terms and so on, that's a pretty light load in relation to dispute around that term. Is that a fair statement?
I think that's a very fair statement.
Yeah. Do you want to offer any comment on the operation of the right in general terms? Anything you'd like to say about the way it has settled into the system?
The only thing that I would I'd offer is that the paucity of applications to deal with disputes, I think would it'd be reasonable to assume that the vast majority of these matters, even before they become disputes, are being dealt with in the workplace between employers and employees.
Exactly as the clause intends. It's specific, isn't it, encouraging first a discussion at the workplace level, and that appears to be where it's occurring. That's what you're saying.
I think that's reasonable to assume that that's what's occurring, yes.
Great. Thank you. I wanted to go to the award review, the Gender Undervaluation Review and the SCADS Award in particular, the Social Community Home Care and Disability Services Award. On the 7th of June last year, 2024, you initiated the review of 5 priority awards, including the SCADS Award, to examine potential gender-based undervaluation of classifications and minimum wage rates. In April, the expert panel issued its decision identifying undervaluation in specific classifications in that award and proposing provisional variations. And in July, you issued a statement regarding the application by the Australian Municipal Administrative Clerical and Services Union to vary the award, proposing to incorporate the 2012 Equal Remuneration Order and adjust the classification structure. This involves merging or adjusting certain levels, as I understand it, particularly in the lower level roles historically held mostly by women. We're talking about support workers, personal care assistants. I'm getting to a question. I just want anyone watching to understand what I'm talking about. The Commission has indicated that the objective here is to improve gender pay equity, but the precise mechanics of the translation may unintentionally disadvantage some employees. A number of people have come to me in my office about this. The Quartus report called Estimating the Impact of the Provisional Classification Structure for the SHADS Award finds that 1, if the new structure was applied today to a sample of 1,816 positions from across the industry, 73% would lose pay and 46% would lose over $200 a week. That impact is very severe in positions focused on financial support, emergency relief, domestic family violence and community legal positions. 75% of positions, I'm told, held by women would lose pay compared to 62% of those held by men. How can the Fair Work Commission say it's eliminating gender-based work undervaluation in the SHADS Award by proposing to revoke the Equal Remuneration Order and imposing new minimum wage rates that are in some instances lower than the present rate? Sorry, that was a very long lead-in.
Thanks, Senator.
I'm sure you know where I'm going, though.
Yes, Senator. I might start with just going back to that. So, as you mentioned, Senator, the Commission commenced a review on the 7th of June, and that's seeking to review a range of classifications across 5 awards, which includes the Social Community Home Care and Disability Services Industry Award. The expert panel for pay equity in the care and community sector, it issued its initial decision for the review on the 16th of April, and it found a number of examined classifications across the 5 awards, including the SHADS Award, have been the subject of gender-based undervaluation, and it further determined that these findings constitute work value reasons justifying the variation of modern award minimum wages. So from that decision, it resulted in determinations to increase the minimum rates of pay for pharmacists in the Pharmacy Industry Award by 14.1% over 3 years from the 30th of June. But then it provided provisional views as to how the remaining 4 awards might be varied to address gender undervaluation, and it set out a process to engage in next steps to seek the views of parties on those provisional views. In relation to the Social Community Home Care and Disability Services Industry Award, it first made a finding that minimum wage rates for employees within a number of classifications, including social and community services workers, disability home care workers, do not reflect the value of the work to which these classifications apply. And this is the case for reasons related to gender. That's in paragraph 376. But it then made provisional views that the current system of classifications and rates of pay in awards were not fit for purpose, did not value work equally across the classification streams, and this was conducive to disputation and potential non-compliance. That's a paragraph 379. And that the award should be varied to replace the existing classification and wages structure with a single new classification structure. And part of those provisional views was to revoke the ERO to make one single classification structure, and that's detailed in the decision. But importantly, going to your question, the expert panel noted that it sought further submissions to respond to these provisional rather than determinative views, so it has not made a determination. In seeking those provisional views, it outlined that this included, it was seeking views as to what transitional arrangements should be implemented to translate employees from the current classifications to the new structure and ensure that no employee has their wage rate reduced because of the transition. That's at 379. And what should the operative date be, and what, if any, phasing in arrangements, having regard to the need to rectify gender-based undervaluation. So I think importantly, Senator, as these were provisional views, it hasn't made findings about whether the provisional views would be necessary to achieve the modern awards or minimum wages objective as yet, and made that clear at paragraph 398. And it indicated it wouldn't do so until it had received and considered submissions that might be made in response to the provisional views. And as you said, we have received a range of submissions, but the process is still underway. And importantly, there are further directions hearings scheduled on the 13th of October to consider the range of submissions which have been put, and there are also hearings scheduled in October and November in relation to the matter.
And does the Commission take the view, given your clear instruction to improve the gender equity in this pivotal award for so many low-paid women workers, especially in the care sector, do you see it as a critical part of your role to ensure that we do not make worse, setting aside grandfathering provisions, setting those aside, transitional arrangements, I'll come back to those, but do you see it as your job to make sure we don't send 75% of women backwards?
Senator, I think from here I can't speak on behalf of the expert panel. The matter is currently before them. They've outlined their provisional views, but they haven't made a determination, so I can't speak on behalf of their decision making.
It seems to me from your description that in an effort to ward off potential disputes and to create a simpler award, there is a real risk of loss of income to significant groups of women. Is that a fair summary?
Senator, the extent and the potential impact of the provisional views is still the matter of factual contest between the parties, and so I can't comment on that based on decisions that have been made by the expert panel.
It would, however, be against the intent of the government, would it not, to have an outcome which makes... I recognise it's still underway. You're making that point. However, I'm interested in your view, Minister, on this. It would not be in accord with your intention here, would it be, to see significant groups of women go back, or low-paid workers, many of them women, go backwards, and to see gender equity go backwards through a decision here?
Yeah, thanks. Thanks for the question, Senator Pocock. I'm not familiar with the issues that you're raising in relation to the SHADS award in particular, but in general, we're really proud of the record that we have in putting systems in place that have raised the wages of women workers. And it's certainly our policy intent, as you imply in your question, that wages of women who are low paid in big feminised industries are improved. That's what we're about. It's why we put gender equity as an object of the Fair Work Act, which has led to the award reviews that you're describing. It's led to the provisional decisions that the expert panel's made. I'm somewhat more familiar, because of my own portfolio, of the implications of that in early childhood education, where a provisional decision's been made for a 23% pay rise in that award. which is substantial. And of course, we've indicated our support for raising the wages of women in feminised industries in the way we engage with the Fair Work Commission, but also the ways in which we've funded really significant pay rises in aged care, a female-dominated sector, and early childhood education as well, with a 15% pay rise that's having profound effects on women. On the care economy and in closing the gender pay gap, which is now at a record low of around 11%. So we're proud of those achievements, Senator.
And I'm sure you are taking that position in relation to childcare workers. It would not be your intent to see financial support, emergency relief, domestic and family violence and community legal services positions, very low paid, mostly feminised, to go backwards through a decision of the kind that we're talking about. You want to see, and I'm putting words in your mouth, but similarly improvements in their pay of the kind that you've seen for childcare workers. Is that your intent here?
I think I just have to be cautious, Senator, because I'm not aware of the specifics of the particular matter that you're talking about. And certainly we're a government that, is proud of our achievements in raising women's wages, in supporting wages in the care economy, in closing the gender pay gap. But I'm not across the specifics of the case that you're raising.
Okay. If I can... Yeah, I've got a couple just to finish off here. I'm very concerned about a provision which would protect current pay rates where they are higher than a new classification structure which lowers a bunch of classifications pay rates, which in their industry would have workers alongside each other, some grandfathered on higher rates than those on reformed, changed classification structures. Is that something that you are attentive to? Do you feel concerned about that from the Commission? What's your view about that?
Senator, again, all I can say is that we have undertaken a consultative and submissions process following the initial decision, which was made on the 16th of April. It sought views on its provisional views relating to the creation of a single classification structure. I can't speak on behalf of the expert panel about its views or its opinion in relation to what you're discussing.
So my last question, the community sector organisations, various have approached me and they are engaged in this review, and they've raised concerns about the speed and the process of this review. Why is the Commission proceeding so quickly to finalise this review? It is, people are coming to me and saying, a real concern to them.
I won't verbal the decision. There have been a range of statements that the President has made around the need to address gender undervaluation in awards, that it's an imperative that it must address gender undervaluation as a result of the Secure Jobs Better Pay Act changes that came into effect in late 2022. The timetable that has been set for submissions has been done so on the basis of meeting those objectives. The Commission has heard from parties in relation to timetabling and it's proceeding to address the matter.
Well, I look forward to hearing about it next time we meet. Thank you. Thanks for your answers, and thanks, Chair.
Thank you, Senator Pocock. Senator Kovacic.
Thank you. Just wanted to confirm, based on the previous line of questioning, as far as you're aware, has the Minister written or discussed with the Fair Work Commission or the Administrator concerns regarding an individual who allegedly organised meetings for the CFMEU with an organised crime figure?
I have not spoken to the Minister about it, but in the normal course of things, it's a matter that relates to an employee of the Construction General Division, and as the Department sort of gave evidence earlier today, the Administrator, all powers, including the powers of employment, vested in the Administrator, and in terms of the meeting with the the person that you're referring to. That's a matter for the administrator to deal with inside the division of the CFMEU.
Even though the actions relate to getting an employee to meet with that individual, that would be under your remit, surely?
The administration, all registered organisations.
The act of an employee of the union, and you're the Fair Work Commission.
Yes, but in terms of the activities of employees within the union, they're subject to the direction of their employer. In this case, the Construction General Division, as administered by Mr. Irving, KC. I understand the issue that you're dealing with. The administrator wrote to me about it, and he called me about it as soon as he'd been appraised of what had occurred.
So the administrator did, yes?
Yes.
Yep. Okay. So the minister didn't, but the administrator has?
The administrator did, because I'm the regulator of registered organisations. I have specific powers and functions under the Administration Act as well. And one of the things that I'm aware that the administrator conveyed to me is that a very senior person in the administration conveyed that Mr. Smith was dealing with a complex industrial issue where the employer continued to engage this particular person as Mr. Gatto as a fixer. And I understand that the basis of the interaction was, what was communicated to me, at least, is that the interaction was that the CFMU was seeking to engage with the employer over the establishment of an enterprise agreement for its members.
Right. Interesting. Thank you. Is the Commission aware if Mr. Smith still has dealings with Mr. Setka?
I'm not aware of that. I understand that...
Has anyone raised that with the Commission as a concern?
No, I understand that that Mr. Smith was sanctioned by the administrator, and the administrator has initiated an investigation in relation to it. He's also issued a policy concerning, it's a draft policy as I understand.
Yes, I heard about that earlier today. I'd read about it before, yeah.
The industrial mediators and other fixers. I can table copies of those documents.
That would be great. Do you know when Mr. Smith was sanctioned?
I don't have that date. I understand that Mr. Smith apologised for his error in judgment.
That's
my
great.
words, not his. But I understand he released a public apology.
If you're able to let me know when he was sanctioned and what the actual sanction was, or perhaps you may know what the sanction was.
Well, no, that was my word. Caution possibly might be a better word, but I should be careful about.
Okay.
Yeah.
Well, if we could find out what that was, or if it was just a caution, well, then there was no actual repercussion. Yeah. Okay. So going back to that question where we don't know if Mr. Smith still has dealings with Mr. Setka. If he did, would the Commission consider that to be appropriate given the administration of the CFMEU?
I would have grave concerns about it. Obviously, but I think that it's important here that we state that it was that the nature of the interaction in this case, the one that we are aware of, we're not talking generalities here. With Mr. Gatto, as I understand it, is Mrs. Smith had asked the organiser to
Yes,
meet.
I'm aware. I was just curious as to the Commission's view if it were come to be known that Mr. Smith were still having dealings with Mr. Setka, and if that would be a problem given the administration.
Certainly I'd be concerned about it, but the nature of my role, and maybe it would help if I sort of step back here a little bit. My ordinary functions under the Registered Organisations Act relate to the financial regulation of all registered organisations, and they continue under the scheme of administration. But under the Administration Act, I have additional powers and functions, including appointing the administrator, certifying rules alterations which persist, receiving complaints from the administrator, and investigating whether the scheme is being effectively implemented. In July last year, sorry, it was July. It was in the 2nd of August last year. I initiated proceedings following the media reports and our own investigations and independent legal advice to initiate proceedings to bring the CFMEU into administration, the Construction General Division into administration. Following that, the government brought the division in through legislation, obviously.
Thank you.
I might just, I want to make sure that we provide you with fulsome answers here.
Sure.
I might just hand off to Mr Enright to see if he wants to add anything.
Your questions relate to, as I understand them, to any contact between Mr Smith and Mr Setka as
if you have any awareness of it, and if you don't have awareness of it, if it did exist, if you would consider it to be a problem given the administration.
Thank you, Senator. One of the things Mr Furlong and I have done intensively over the last 12 months or so have been to engage with all parties and industries, and including the employers and employees, including within the CFMEU and those connected. What that's resulted in, Senator, is a lot of conversations with people within the industry. I must say, Senator, that it has been raised with me that there has been contact, purely and unsubstantiated.
Between Mr Smith and Mr Setka?
That has been raised with me, Senator,
right.
and it's something that it's unsubstantiated and unproven.
Has it been raised on more than one occasion?
It has, Senator.
But how many occasions, roughly?
Please forgive me for interrupting, I'm sorry.
Yeah, I was just saying roughly on how many occasions?
It's been raised with me on 2 occasions, yeah. Senator, and again, I have to stress, it is unproven and part of a great many conversations I have with people in the industry, and I can't say any more than that, Senator, at the present time.
Would you be comfortable telling me in general terms who raised it, whether it was another member of the CFMEU, someone in the industry, an employer, or if you're uncomfortable, I
would be entirely uncomfortable, Senator, given the confidentiality of discussions that I've had. And in terms of the context of it, because it's, I was going to say unprovable, but because it's unsupported. I'm in the process trying to ascertain whether those reports are true or not, but I can't take it any further than that.
Sure. Then I have another question connected to that. Would Mr Smith have to declare any contact with Mr Setka to the administrator? Would he be required to do that? Yes.
He's required to do that, and in terms of the policy that I will table, the CFMEU policy concerning industrial mediators and other fixers. It requires every employee, every office holder, ultimately, to the CFMEU to, and it does a number of things. They have to ask for permission before engaging. There's a
is that with contact with removed persons?
The removed persons, yes.
Right, yeah.
Well, removed persons as prescribed or defined by Mr Irving's policy.
So is that in place now, or is that going to be in place?
My understanding is that it's operational now, but it's the draft policy. Yeah.
Because what I was going to ask, and this has sort of changed the flow of my questions, but the CFMEU's administration report and statement of expectations for all staff, is that approved, and if not, why is it taking so long? Because it's more than a year into the administration. And my question was going to be, do those expectations include no contact with removed persons or former members of the union? But you're saying to me it includes perhaps currently a requirement to declare or request permission to meet prior to meeting.
Yes, I have a copy of the...
You're tabling that for us?
Yeah,
thank you.
The policy. Mr Irving also wrote to Mr Gatto seeking for him not to engage with any officials or any organisers of the CFMEU as well. And he notes in it that if that were to occur, then it could possibly impact on his ability to effectively administer the scheme, which would enliven one of my powers as a regulator and to receive a referral from the administrator about anyone who's ultimately sort of, my words once again, hindering or obstructing the administrator in his ability to administer the scheme.
I'm just having a quick look at this, and I'll ask another quick question. The Fair Work Commission, you would have responsibility for Mr Smith as well, given he's an administrative executive director of the Victorian branch. Is that right?
The administration, like all registered organisations, is independent and operates separate to government, and certainly from direction from me. I am equivalent of, in some ways, of ASIC. So the conduct and any sort of criminal conduct that may be occurring within the by employees of the Construction and General Division, those matters would be referred to the relevant authority, and it would either be a regulator or a law enforcement body.
So you were able to remove Mr Smith from his role if you deemed it necessary?
No.
So who can? Only the CFME, only the administrator? As
an employee, yes.
Yeah.
Previously, and in terms of the removed persons, the 200 or 200 plus officials who were removed persons under the scheme who held office prior to the commencement of the administration last year, each of those, each of the people who held those offices, including a smaller number who held their employment by virtue of the offices that they held as well, are no longer with the no longer sort of have the powers vested in them, and a small number of them lost their employment as a part of it.
So thinking about this more broadly, Mr Furlong, in your own statement on the 3rd of October about the administration of the CFMEU, you said that they needed to promote high standards of accountability of office holders under the Registered Organisations Act, and I think that's a given, we all agree with this. But do you think that this sanction or caution or whatever it is for organising a meeting with an organised crime figure is actually sufficient in your view, and particularly meets that high standard of accountability?
I think that, to contextualise this, I think that we're sort of 14 months into up to a 5-year period of administration to deal with endemic issues. I have significant experience in this industry from a regulatory perspective, and I have to say that every participant in this industry needs to be part of the solution. I believe that Mr Irving is, and if you have a look at the report that that was tabled in Parliament, this is his second biannual report, has done a significant amount to bring the matters that are within his control into lawful sort of compliance and conduct. I believe that there is still a lot of work to be done, and I just want to return to my earlier evidence about the reason, and it is obviously inexcusable, but the reason why Mrs Smith had requested that organiser to meet with Mr Gatto was because my understanding is that Mr Gatto was holding out that he was representing the interests of the employer in the case, and my understanding is that that Mr Smith was dealing with a complex industrial issue and seeking to secure an enterprise agreement for the workers of the construction company involved.
I've had a quick scan of this document. I'm not as fast a reader as I once was. I note in here it says that CFMEU employees are not to meet with identified mediators and other fixers. CFMEU employees are not to permit or facilitate identified mediators and other fixers entering the premises of a union, and they're not even to email or text them. And it says the direction above applies to engagement even about non-work related matters and outside of work hours. If, for example, any CFMEU employee feels that they wish to meet with and talk with the head of an outlaw motorcycle gang, then they may write to the administrator and seek a dispensation providing reasons why the organiser wants to spend time enjoying such company in a simply social context. So I'm assuming obviously then as well from a work perspective they can't. So under this, which was adopted on the 22nd of September 2025, I understand it was unanimously adopted, the conduct of Mr Smith would be considered in breach of this document. If that conduct occurred after the 22nd of September, what would happen to Mr Smith or any other employee of the CFMEU who engaged in that conduct?
I understand that...
Without seeking permission from the administrator first.
Yes. Obviously, whatever sanctions would be...
What should happen? Should they be cautioned again? Should they lose their job? Like, what should happen?
I think that's a matter for the administrator.
Right.
I know that the administrator has warned Mr Smith that he will not tolerate any contraventions of the policy, and that Mr Smith has acknowledged the serious mistake that he has made.
Well, the policy's been contravened. I mean, obviously this was implemented after those reports, but...
It might assist you, Senator, that the General Manager does, in his regulation of registered organisations, part of that regulation relates to the duties of an officer, like elected officials. You were talking about people being elected officials, which are different to employees. There are obligations, and we refer to them as collectively as directors' duties type obligations in the Fair Work Registered Organisations Act, and they relate to acting in good faith, using position for proper purposes, acting in the interest of the organisation and things of that kind. The General Manager has jurisdiction in relation to that. So the General Manager could... It all depends on the circumstances, of course, but so the powers of the General Manager are focused, generally speaking, in relation to officers, in a limited way in relation to employees.
So what real scope does anybody have to eradicate this behaviour? We know it's wrong. We can write a policy to say it's wrong. We can caution, we can sanction. We can do all of that, and yet ultimately nobody can tell me what the process is to remove an individual, not just from their role, but from a government body, from a government board, when they conduct themselves in this manner.
So my response to that question is that there has never been a policy like this, as far as I'm aware, that's existed, and now there is. And whilst we all wish that this conduct didn't occur, that didn't exist, that hasn't existed for a very long time in the commercial building and construction industry, this policy does exist now, where it didn't exist for at any, as far as I'm aware, at any point in time.
I think it's extraordinary that we require a policy like this. I don't know if there's any other organisation in this country that requires a policy like this. Are you able to direct me to one?
No, I'm not. But I mean, I'm just going to reiterate that every participant in the building and construction industry has a role to play in improving the conduct, the unlawful, the illegal conduct in the industry.
Sure. So going back to my comment earlier about the CFMEU's administration report and statement of expectations for all staff, can you let me know why it's taking so long to approve?
No.
So no information whatsoever has come to you? As to
I haven't asked. I certainly haven't asked the administrator.
No one's curious why we're a year in and it still hasn't happened?
Certainly curious, Senator, but in terms
not
of
curious enough to ask?
No, I wouldn't say that. What I would say is that these issues came to light last week.
Gotcha,
the issues are endemic, They are occurring across the nation. The administrator, and I hope that you've got access to his second biennial report that outlines everything that a significant number of his operational activities. It also contained a strategic plan for the administration, including some key areas that he will be focusing on. I've looked at that reasonably sort of closely, and I'm satisfied that each of those areas has got active work occurring against them.
Okay, and just to be finish on that bit, will those and I think you answered this before, but just to clarify, will those expectations include no contact with removed persons or former members of the union?
I could take that on notice,
okay.
Whether or not it's within my operational remit to actually. I can ask the administrator for that information.
Okay.
Yeah.
The administrator in his report states, in the National Construction Industry Forum, Blueprint for the Future Unions, Employers and Government, there was a firm commitment that criminality and violence would not be tolerated. And I quote, it said, "This needs to be more than an unrealised vision." But Mr Smith arranged a meeting for the CFMEU with members of organised crime, and the NCIF is a forum setting the future direction of the policy that the minister shares in. Surely we can't sit here and defend. Surely he can't remain in that position. Is the administrator really prepared to let that go with a caution?
I can't speak on behalf of the administrator, and I'm not a participant in the NCIF.
Okay, so only the administrator has power to remove people, and are you able to answer for me why this has not been done? You've had no conversation with the administrator about it?
I think that I've outlined what the administrator has done in response to this. The information was raised last week. Since then, the administrator has initiated an investigation into what has occurred. He's issued this draft policy. He has warned Mr Smith that he will not tolerate any contraventions of the policy, and that's effectively what's occurred in the last week.
How many more questions you've got? Because I won't return the call and come back to you if you've got another block in you. We've just been continuously.
Yeah, do you want to share the call and I can come back?
Yeah, we'll do that.
Yeah.
So I'll go to you, Senator Delaga.
Thanks very much. Thanks everyone for coming in and bearing with us as we get into the evening. I referred to the recent decision made by the Commission on the 3rd of June 2025 relating to the annual wage review. Can the General Manager provide a summary of the decision made relating to the minimum award wage earners and how many workers were affected and what was the final decision?
Ms Lager will be able to assist you with that question, Senator.
Thank you, Senator. As you mentioned, Senator, the annual wage review decision was handed down by the expert panel for annual wage reviews on the 3rd of June. And in that decision, it decided to increase the national minimum wage and modern award minimum wages by 3.5% with effect from 1 July. The announcement of decision estimated that approximately 20.7% of all employees in Australia are paid the applicable minimum wage rates in the 121 industry and occupational awards in operation, and that they were principally affected in a direct way by the decision. We can table, of course, the decision and the announcement of decision if that would assist.
Thank you. That would be great. Can you outline the types of industries where, excuse me, can you outline the types of industries where most workers who will benefit from this increase?
The decision does discuss in some detail industries which are particularly award reliant and awards which are have high levels of award reliance. I might take that on notice. There are particular provisions within the decision which go to the particular industries and sectors which are highly award reliant and which are more likely to be impacted by the decision.
So taking that on notice, you may not be able to tell me the characteristics of workers who rely on in those industries who rely on that on the minimum award wages.
There is a degree of detail in the decision about the characteristics. It's outlined in Table 1 after paragraph 16 of the characteristics of modern award reliant employees. It speaks to that there's a high degree of part-time. Modern award reliant employees are more likely to be part-time, to be female. For example, but it's detailed in more detail at Table 1.
I've got that here now as well.
Yep. And just going to your question just before around, modern awards that apply to the most modern award reliant employees and their related characteristics. It outlines 10 awards. That are more highly modern award reliant, and that's at Table 2 of the decision, and that speaks to the General Retail Industry Award, the SHADS Award, the Hospitality Industry General Award, the Fast Food Industry Award, Restaurant Industry Award, Children's Services Award, the Health Professionals and Support Services Award, the Building and Construction General On-Site Award, the Cleaning Services Award, and the Clerks Private Sector Award.
So just to clarify, these are some of the most lowest paid workers who are reliant on the awards.
It outlines that those are the modern awards that are most modern award reliant, and then it goes into some detail about what the characteristics of the employees that are covered by those awards look like, and the percentage of which they are more likely to be low paid.
Thank you. Thank you, Chair.
Thank you, Senator De Lager. Senator Kavasic, I'll return the call to you, and then we'll be going to Comcare.
Thank you. So the biannual report that I mentioned earlier actually came out before all of these media reports, so I'm a bit confused as to the timeline. So effectively, the biannual report stated that none of these things would be tolerated, and then we had the media report about what transpired with Mr Smith. And then, we know that Mr Smith is now very, very sorry, as many people are once they're caught doing something that they shouldn't be doing. So I guess the question that I've got is, what is actually the threshold for the administrator to go, we can't tolerate this? We're an organisation in administration for criminal and corrupt conduct. We've got a senior organiser continuing to engage in that conduct. Yes, they've said they're sorry. That senior organiser sits on the NCIF. They're still sitting on the NCIF, which is a body about the future of the construction industry and changing it and making it better. Like, am I alone here in saying that is totally incongruent, that doesn't work, that doesn't fit? Like, what do we do? How do we change this? And who does it?
The administrator's investigation hasn't concluded in relation to these events. We're back before you in early December. I imagine that investigation, while it's a matter for the administrator, may be concluded by that point, at which time I may have some further information I can provide.
Okay. Senator, the Commission, the General Manager and our partners, our very significant focus, you ask about changing, is changing the culture. And we're looking in the future. Ultimately, at some point, the CFMEU will be returned to the CFMEU, and the General Manager's talking about and
It
making...
won't be for a very long time if this continues.
The General Manager is having discussions with people about the sorts of things that will need to be implemented in order to effect proper change, such as new training programs, how to influence, how to change the culture. That's the focus of a range of both the Commission, the General Manager and others. So it's very much at the forefront of our thinking, Senator, about how to change that culture to a more positive culture. That's one of the functions of the General Manager, is to embed a positive culture of good governance, and that's what we think it's important, and many of the efforts being taken now amongst all of our stakeholders is exactly that.
I guess the problem that I have sitting here listening to all of this evidence and hearing all of this information is how an organisation will allow somebody to remain in it when they are trying to change, when they're trying to fix culture, when they're going through this significant process of an administration, and yet they allow people to stay in it who continue to taint the organisation and any good people in it.
Senator, I understand where you're going with this, and I appreciate it, but I feel like we're bordering on opinions here, and we just need to be careful to be putting questions which are...
I just don't know what we need to do.
So if you could perhaps think about rephrasing your question to be,
How bad does it get before the Fair Work Commission says to the administrator, this has to stop, you have to act?
My role, as I indicated earlier, it's not my role to, as with any registered organisation, to dictate at a micro level the way that an employer deals with, and the same with any employment relationship, deals with employees. That absolutely sits with the administrator, and would be inappropriate for me to give I certainly don't have the power to provide the administrator with any direction in relation to that.
I understand. I'll just finish here. I assume the Fair Work Commissioner doesn't believe, or the Commission does not believe, that violence is acceptable or verbal abuse is acceptable in the workplace.
No.
Whether that workplace is, a supermarket, a fast food chain, or the CFMEU.
No, I absolutely agree with that statement.
Okay. Nor is meeting with organised crime. Anyway, thank you, Chair.
Thank you, Senator Kvasic. I believe that ends the committee's questions for the Fair Work Commission, so I'd like to thank you all for appearing before us today. I believe we've got Comcare in the room, so it should be a quick shuffle to the table, but we'll suspend for less than a minute as we do that. The committee will resume, and I call officers from Comcare, including the Acting Chief Executive Officer, Mr Michael Duke. Welcome, Mr Duke. Do you have an opening statement today?
No, Senator. Thanks.
Excellent. Senator Roberts, you have the call.
Thank you, Chair, and thank you for appearing again tonight. Can you please explain to the committee the results of your investigation into the MRH-90 Taipan helicopter crash in Whitsundays, please?
Thanks, Senator. In terms of the investigation, I just note the investigation remains open, so we are the investigation does remain open. There are still active lines of inquiry into this matter. I think in terms of the investigation itself, obviously, following the incident being notified to Comcare, we established a team to investigate the matter. That involved the extensive investigation that gathered a whole range of evidence across a number of lines of inquiries.
Could I interrupt you just for a minute? What sort of people did you involve? Did you put on the investigating group, and how many different varieties of people did you interview?
Yeah, so we have a specialised investigation unit within Comcare, and so that team was assigned to this investigation. The number of people, I might ask the General Manager of Regulatory Operations, or we can take it on notice perhaps. But
I think we need to take it on notice.
I'm particularly interested in the range of expertise on the group.
I might ask the General Manager of Regulatory Operations.
Thank you. Justin Napier, General Manager, Regulatory Operations Group. So we do have a team of investigators that are involved in incidents like this, and from time to time we will involve what we call subject matter experts and bring them in to assist us with some of the more technical aspects of the investigation.
So could you tell me about any topical experts that you brought in on this case?
I don't have that detail at hand, but we're happy to take that on notice. So far as we're able, I do make the point that we still have an ongoing investigation in relation to these incidents, so we may need to be a little careful in terms of information that we provide at this point in time.
Thank you. Thank you for accepting my interruption. Keep going.
Specialised investigation team. That involved gathering evidence. The gathering evidence process is obviously a lengthy piece. There's ultimately when an incident like this occurs, we start to narrow a scope in terms of what are the types of things that we are looking at. Where obviously our investigation, and as you know, there's a number of different types of investigations, inquiries into this incident. Ours is very much focused in relation to the Work Health and Safety Act and the safety elements and the obligations of the employer under the Work Health and Safety Act, or the entity under the Work Health and Safety Act. And so over a period of time, that involves gathering evidence from witnesses. It involves gathering documents from various documents. As Mr Napier referred to, it might involve gathering specialist information from specialist witnesses who have technical knowledge that we can draw on. So in essence, that's how the investigation ensued.
Okay, thank you. The documents produced under the Senate's order detail the potential Category 1 and Category 2 offence. Can you explain what those mean in the context of workplace health and safety?
I might ask my Chief Legal Officer to sort of explain the actual meanings of those from the legal perspective, so I'll pass to her.
Senator, could I just ask you to repeat the question, please?
Sure. The documents produced under the Senate's order detail the potential Category 1 and Category 2 offence. Can you please explain what these mean in the context of workplace health and safety?
Thank you, Senator. I'm Louise Close, General Manager of Comcare's Legal Group. The documents you've referred to that were produced under the Senate order are broadly referred to as investigation summaries, in which an investigator has offered a view that there is evidence capable of forming a basis for offences against the Work Health and Safety Act, specifically Category 1 and Category 2 offences. Those are offences where a person holds a health and safety duty and does not meet that duty in certain circumstances, including where there is reckless behaviour. That's a Category 1 offence.
Category 1 is reckless.
Yes, and the Category 2 is holding a health and safety duty in circumstances without the element of recklessness.
Thank you. So with the Defence Forces, I understand they're pretty strong on documenting processes, correct?
Probably a better question for Defence, but I think it's not unreasonable to assume that.
Yeah. They seem to standardise and regiment, and that's not a criticism of them. That's an endorsement in many ways for some of their operations. I understand that's a secret to our Army and Defence Forces' strengths, actually. Did they violate any of their own standards?
But that's not the subject of our inquiries, okay, Senator, so we wouldn't necessarily have been focused on that. We'd be looking at we may have gathered evidence towards whether they followed their own policies and procedures, but that wouldn't have been the sole purpose of our investigation. We would have been looking more broadly at other matters and other controls that they may have had that went to safety risks.
Okay, and I don't want to be seen, or I'm not even trying to lead or anything like that, lead your comments. I just wanted your perspective, honestly, on the record.
Yep.
Were you disappointed at the prosecutor's decision not to lay charges in relation to the investigation?
Senator, I think personally, yes, I was disappointed.
I do think that's bordering on an opinion, so it's up to
Sure.
you how you choose to answer it. But
So I would say, Senator, we've accepted the decision. We understand why the decision was made. Our focus at the moment is really on the ongoing investigation that we do have and really looking to ensure a safety outcome is achieved.
Yep, and I'm not trying to embarrass you because you've mentioned that 3 times now, and I understand your concern. It is ongoing, so I respect that.
Yeah.
Were you confident in your investigation in terms of the potential breaches you identified? Sounds like you were.
Senator, we conducted a very thorough and comprehensive investigation and satisfied that we did all things under our powers to gather the evidence and prepare a brief.
Thank you. We heard from the prosecutor that they may not have called for further documents. Were there any documents in particular that weren't directly included in your brief to the prosecutor that you would have expected them to call for?
Sorry, could you just ask that question again, Senator?
So we heard from the prosecutor, as senators, that they may have not called for further documents. Were there any documents in particular that weren't directly included in your brief to the prosecutor that you would have expected them to call for?
Not that I'm aware of, Senator. I'll just check whether my colleagues are aware. No, Senator.
Okay. Well, Chair, I thank the witnesses for their direct answers and short answers and very informative. Thank you. Thank you very
Senator.
much.
thank you, Senator Roberts. Senator Kovacic.
Thank you. My questions relate to complaints. Would you be able to tell me how many complaints Comcare received from APS employees over the last 3 financial years?
So, Senator, just in terms of terminology, do you mean complaints about us or do you mean complaints about APS?
Not about you. Yeah, not about you.
Yeah. So you're talking generally about work
Yes.
health and safety
Correct.
matters,
Yes.
those sorts
Yep.
of things. I'll
Yep.
ask my General Manager
Thank
of
you.
Regulatory Operations to give you those figures.
Yes, we receive, if you just bear with me, I'll see if I can quickly pull that one up. So from the WHS side of things, we receive what are called incident notifications, which is an obligation under the Work Health Safety Act. So I can give you that number, but in addition, we also encourage what we call WHS concerns, so issues in workplaces that don't ordinarily meet the threshold under the WHS Act. So I can give you both of those figures. They're not, I wouldn't necessarily categorise them as complaints as such, but they're more matters that come to our attention through those various channels. And sorry, I've got a lot of material
okay.
here. I might come back to that. I have got that, but it's not in
sure.
this particular brief, if that's okay.
Yeah, no problem. And then I was also interested in breakdown of complaints by department or agency over those 3 years, and if you have that available, and if not on notice, is fine.
That last one's probably likely to have to be taken on
notice. That would
Senator.
be great.
And can I just
Sure.
just to clarify? So that's related to the work health and safety. Obviously, we
Yes.
have a workers' compensation side that deals with what we would call claims for workers'
Yes,
compensation, but your focus is just on that work health and safety element.
Correct. That's right.
Thank you.
So also the number of complaints by category as well, where we talk about, bullying, harassment, psychological injury, workplace safety, and then maybe just a separate bucket for that workers' comp, just so we know what that category is.
Sure.
But then just the complaints by category would be great. Do you have any data on the annual trend in total complaints and accepted claims since 2020 and since the 2020-21 year?
I could give you some data in relation to the workers' compensation trends, if you like. I'll just bring that forward. Senator, just in laying this out, the Comcare scheme involves sort of what we might call as 2 distinct sectors. There's the self-insured element, which includes the self-insured licensees who are licensed to manage their own claims under the scheme. And then there is what we call our premium-paying entities. That's typically the Commonwealth entities. I've got breakdowns of all of that, but if you want me to focus in on the Commonwealth entities or the scheme as a whole, it's up to you.
I think the Commonwealth entities is fine.
Okay, so
and then you can provide any additional information on notice. Yeah.
Sure. Okay, so for our Commonwealth entities, in terms of what we call our premium payers, I've got to 2022-23 financial year, there were 1,481 claims received. In that same year, we would have had 919 of those claims accepted. For 23-24, we had 1,745 claims received, accepted 1,031.
Yep.
And for 24-25, we have 1,760 claims received, 1,021 accepted.
Wonderful. And then the balance of those would have been dismissed or withdrawn, obviously.
Yeah, and also just timing-wise, obviously some lodged later in the year might have been determined the year after, so there's a bit of sort of crossover and those sorts of things.
Okay, lovely. Chair, I'm happy to put the rest on notice.
Thank you. That concludes the committee's questions.
The one that I asked prior as well, on notice as well. Thank you.
Thank you, Senator.
That concludes our questions for Comcare. Thank you for your
you.
participation this evening. Before I call Safe Work, but a note to Safe Work to start making your way over if you're not already here. I understand the Senator who called Australian Skills Quality Authority no longer requires this agency. I'll just check at the table if anyone else has questions for them, otherwise we'll let them go. The Coalition did not call them, Senator.
Yeah.
Okay. In that instance, we will be in a position to release the Australian Skills Quality Authority. But we'll now be moving to Safe Work, so we'll just suspend for a minute to enable us to do that. The committee will now resume, and I call officers from Safe Work Australia, including the Chief Executive Officer, Ms Marie Boland. Welcome, Ms Boland. Did you have an opening statement?
I don't, Senator. Thank you.
Excellent. Senator Kovacic, you have the call.
Thank you. Has the Safe Work Australia received any correspondence from WorkSafe Victoria regarding the appointment of Miss Cathy Henderson?
Directly from WorkSafe Victoria?
Yes.
No, not that I'm aware of.
Okay.
No. Yeah.
Have you received any concerns or complaints more broadly about Miss Henderson's appointment?
No, we haven't.
None whatsoever?
No.
Has the Federal Minister considered the appointment of WorkSafe Victoria's new CEO as a member of Safe Work Australia?
Minister.
Shall I take that one? Is that a question for me?
Yes, sorry. Yes.
Sorry, Senator Kovacic, could you repeat the question?
Has the Federal Minister considered the appointment of WorkSafe Victoria's new CEO as a member of Safe Work Australia?
I'll see if I can get you any information on that, Senator Kovacic, while we're here.
Wonderful, thank you. And otherwise on notice. Thank you. There's some reporting this week concerning Ms Henderson's appointment in Victoria, and I'm able to table that if required. Given Ms Henderson is likely to sit on Safe Work reports, has any advice been provided to the Minister appointing her to Safe Work in relation to those reports?
Can I just say the appointments to Safe Work Australia are managed by the department, so they're not directly managed by the agency. So any correspondence or appointment procedures are managed through the department's appointments process.
So you don't provide any input or feedback on any of that, or you're not required to?
We're not required to generally, yeah.
Okay.
Yeah.
So if you say generally, that's just as a rule, like there are no circumstances under which you would?
No, I mean, generally the practice has been we are notified as to who each Safe Work Australia member is representing each jurisdiction. So it's a matter for we're just notified when the appointments are made. Yeah.
It's odd because the department said to talk to you guys about it.
No, we're kept quite separate from the process.
So earlier today, when this question was asked, they said that Safe Work is the appropriate body to ask about this.
Yeah. No, we don't deal with the appointments, so yeah, that's been the common practice over all
Minister,
the years.
what do we say about this? We've got two agencies each saying that it's the other. Oh, sorry, Minister. Yeah, what do we do about that?
I'm going to take your question in relation to this matter on notice and come back with what information we can share with you.
Okay. All right, interesting. Minister, on the 26th of February this year, at the last estimates, we were told that the committee was told that Tony Marr, the head of Mining and Energy, the head of the Mining and Energy Union, was a really good appointment who spent his entire working life standing up for the safety of workers. Is that still the view of the Minister?
Senator Kovacic, can you just clarify what appointment you're talking about there? I missed some of your preamble.
He's the chair, my understanding, of the Safe Work of Safe Work Australia. Let me just check that. I've just got notation of the chair.
He's our chair. Yeah.
Yeah. Right.
Yeah.
Okay. I don't have any issues with that appointment.
Okay. Are you familiar with the section of the Safe Work Australia website entitled Who We Are and What We Do? And there's a quote there that says, all workers, regardless of their occupation or how they are engaged, have the right to a healthy and safe working environment.
Is that me?
Yeah, we're familiar with that. And we all agree that that's an appropriate sentiment for all workplaces.
I believe you, Senator Kovacic, that you've read something from the website.
Yep. Okay. And so Safe Work Australia is the national body tasked with giving effect to that principle. That is correct. We all agree with that, yes? Minister, are you familiar with the Federal Court's decision of what was known as the Oakey North Scab case, which imposed a record penalty on the Mining and Energy Union in relation to conduct at a certain picket line at the Oakey North mine?
I am not, Senator Kovacic.
Okay. I'll quote then from a news story in the Financial Review on the 19th of September 2024, entitled Record Fine Over Scab Abuse at a Picket Line. It says, union officials, including former Queensland Mining Union leader Stephen Smythe, ended up calling non-union workers scab, dirty rat, a word I'm not going to say, maggot, dog, something, mutt, grub, dog, another word I'm not going to say, from the picket line. Do you think that this sort of conduct is consistent with the safe work principle that all workers have the right to a healthy and safe working environment?
I'm not sure what the material is that you're quoting from, Senator Kovacic. I'm not sure whether you want to table the material that you're referring to.
Okay. That's the link to the article, but I'll get the full article tabled for you, but that's the link for the article. Okay. While that's going through, Minister, are you aware that the court fined the Mining and Energy Union $535,000 for this unsafe and unhealthy workplace conduct?
I'm not.
You're not familiar with it?
I'm not, Senator Kovacic.
Okay.
I'm not familiar
well, ultimately, Tony Marr was the national head of the Mining and Energy Union at the time of this conduct in 2017. So he oversaw that conduct. That was widely reported. So I'm trying to understand whether that conduct that, and the comments that I read out earlier, much of which I wouldn't read out, is consistent with a safe workplace. And then we have a person who oversaw that, effectively now being the chair of Safe Work Australia. Is that consistent with what we consider to be safe work practices?
I think I'm awaiting the material that you're describing, Senator Kovacic.
It was only a link, so the Secretariat's just seeking the article and printing it.
Thank you.
So it'll take a moment.
Would you like to give somebody else the call in the interim, Chair?
Well, we are due to go to a break in 3 minutes' time, so if perhaps we want to take a brief break.
Would you like to do that?
And then we'll return. May I suggest we take till 10 past, unless there's opposition to that? For a bit of a comfort break? Okay. So the committee suspends and we'll return about 10 past 9. The committee will now resume. We're returning to Safe Work, and Senator Kvassett, you're in continuation with the call.
Thank you. So, Minister Walsh, the article has been tabled, and I will leave that with you and my point, and I'm happy to take on notice the answers to my questions in relation to that, particularly in relation to whether it's conduct consistent with what the government would expect of the chair of Safe Work Australia. So I will leave that there. I'll move on to some questions in relation to the functions of Safe Work Australia. Could I get an understanding of how many health and safety representatives have gained access to sites without a right of entry permit?
Sorry, could you say that again? How many health and safety
representatives have gained access to sites without a right of entry permit?
Safe Work Australia is actually the policy agency, so we develop policy and maintain the laws, so we're not actually a regulator.
So you don't have any access. I understand you're not the regulatory body, but
yes,
would you have access to that information when you're developing your policy?
No, the type of data we collect is in relation to fatalities, injuries, workers' compensation claims. So that level of detail, that kind of data, I imagine, is more relevant to perhaps the regulators or
yeah, no,
or the
I
Fair Work
understand.
Commission.
I was just curious whether you get access to that information at all.
No, we don't.
Okay. So the only information that you receive is in relation to policy development.
Yes, and we do have quite a large function around data collection, but as I said, it's mainly around those injury and fatality statistics.
Okay. Yeah. So in the policy development space, have you been involved at all in discussions around AI?
Yes, AI is quite a significant area of interest for us at the moment in terms of policy development.
Okay. In relation to AI, have you had any sort of, has your mind gone to the impacts to small businesses, to how they navigate and manage the risks involved with AI and their employees? Have you looked at that?
Yes. So, Senator, what we are emphasising through our guidance and education is that the model work health and safety framework as it currently exists is principles-based, and so the primary duty under the Model Act requires businesses, whether they're small, medium or large, to ensure the provision and maintenance of safe systems of work so far as is reasonably practicable. So as such, where AI systems are introduced, businesses must already consider the impact on workers' health and safety and control the risks so far as is reasonably practicable. So we're really reinforcing to business, and particularly small business, that the basic work health and safety risk management fundamentals are essentially what needs to be applied to the risks associated with AI in the same way as they're applied to any other hazard or any other change in the workplace. So those fundamentals are consulting with your staff, assessing the risk, eliminating or minimising so far as is reasonably practicable. So our first education, I guess, is to reinforce the current obligations, and that we believe that the current primary duty that's in the Act already requires businesses to put their mind to these risks in consultation with their workers. But obviously we're also keeping an eye on developments as they occur. We're obviously alert to some of the inquiries and parliamentary inquiries and other inquiries that have made recommendations, and we're constantly consulting with employers, unions and regulators around the potential impact of AI in the work health and safety context.
Okay. And have you provided any advice yet to the department or the minister regarding AI and best practices moving forward? And I know you've talked about, current, focusing on current matters.
Yeah.
Have you sort of looked at any sort of future proofing, I guess?
Yes. So we are, as you'd be aware, we are responsible to all the ministers, so not just the Commonwealth ministers. So ultimately, because the model laws are implemented across all the jurisdictions, it's up to all the work health and safety ministers to make decisions. So we have actually provided all the ministers with some information about work we're doing, and we've asked them to basically give us their view and approve or not further policy work in the AI space. So we're currently waiting on ministers' responses
to come back to you,
to come back to us. Yeah.
And then after that, you're able to develop perhaps some models on WHS laws and guidance materials that are future focused.
Yeah,
so you're waiting on the ministerial feedback first.
Yeah, exactly, Senator. And the other important work that we're doing at the moment is what's called the best practice review of the model laws. So we've been, agency staff have travelled all around the country meeting with business, industry, unions, regulators, everyone really who wants to meet us and, is willing to meet with us to discuss how we can make sure that the work health and safety laws are keeping in step, I guess, with all the modern developments, not just AI, but AI has come up quite a lot, and so there is a genuine call out there from everybody, I think, with an interest in work health and safety, that we keep our eye on the ball. And so that best practice review will continue until early next year, and then we expect that there might be recommendations, and given AI is featuring quite strongly, there might be more kind of concrete issues coming out.
Thank you.
Yeah.
My next question relates to the Closing the Loopholes Act, and I know that you're a policy arm, not a regulatory arm, and the provisions enabling union officials to assist health and safety representatives without requiring a federal right of entry permit. Can you tell me what, if any, assessment, safe work made of how this policy aligns with the broader objectives of maintaining safe and lawful work sites, and any inconsistencies or incongruence there, particularly in sectors with a history of compliance issues such as construction?
Yeah, look, I mean, obviously, as you suggest, there is that's the crossover between industrial and work health and safety in the question. Look, we as the policy body, I guess, the members representing the jurisdictions predominantly come from the work health and safety regulators. So I guess that's our conduit to information that would support any policy work we need to do. And again, as part of the best practice review, we've been talking to the regulators in each state and territory. We've been talking to health and safety representatives, and so that's another avenue, I guess, for us to have a look again at some of those crossover issues and see if there's anything within our model laws that we need to look at.
But no policy work was required of you prior to that legislation being introduced? In terms of that incongruence?
I just hand to Ms. Wallbank. I think she's here.
Yeah, so Angela Wallbank, Group Manager at Safe Work Australia. Sorry, not a very helpful answer, but I understand with the timing of that closing loopholes legislation, it was sort of before our time, so I think we're going to have to take that one on notice just to check what and if we were asked to comment or have any input.
Thank you. I guess then thinking about that in terms of a policy perspective, have you then been made aware of any concerns or feedback or evidence suggesting that legislative change or feedback since has had unintended consequences on work sites that has affected safety outcomes that would require you guys to have a look at some potential changes or any necessary changes?
Do you want to ask Nathan?
Yeah. I mean, I haven't specifically, but
we might just ask Mr. Lee to come to the table because. Oh, he's got nothing to add. Oh, yeah. The only reason I was asked because he's the one who's trekked around the country, obviously it hasn't come up for him and the team when they've been doing their consultations around all the states and territories.
Okay, thank you. Then we might take that one on notice as well.
Yeah, thank you.
Okay, thank you, Chair.
Thank you, Senator. I believe that concludes our questions for Safe Work, so thank you very much for your attendance today, and I'll now be calling the Coal Mining Industry Long Service Leave Funding Corporation. I'd like to welcome Chief Executive Officer Ms Darlene Perks. Ms Perks, do you have an opening statement today?
No, I don't, thank you, Chair.
Okay, excellent. Senator Roberts, do you have the call?
Thank you, Chair. Thank you, Ms Perks and everyone from Coal LSL. Mr James Joseph was injured on BHP's Mount Arthur coal mine on 7th of June 2023. You familiar with James Joseph?
We're familiar with James Joseph, yes.
With what?
Sorry, yes, familiar with the individual, yes.
Coal LSL have confirmed with Mr Joseph that they were not informed of his workers' comp status, which was approved in May 2024 following a 6-month delay. Mr Joseph's correct workers' compensation status seems to not have been reported to Coal LSL by the BHP or their insurer, Coal Mines Insurance. Coal Mines Insurance has the board of directors has 50%, as I understand it, 50% mining and energy union directors and 50% coal owners.
Senator Darlene Perks, CEO of Coal Long Service Leave. I'll answer the last part. So the shareholding of Coal Services, I think, is what you were just referring to, which is the workers' comp.
Coal Mines Insurance?
Yes, yep. It is, I can confirm, not an organisation, obviously, that we have any relationship with in our jurisdiction, but I can confirm that the shareholding is, as you've reflected, Minerals Council and QRC, and CFMEU.
That's the composition of the board, 50-50.
Our board?
No, it's Coal Mines Insurance Board.
I can confirm. I think they do have independent directors, but that's
What about your board?
Our board? So our board, the legislative framework hasn't changed in all the hearings that we've been. So our board has 6 directors who are appointed by the responsible minister. 3 directors are nominated by employer companies bodies, and 3 directors are nominated by union organisations, but minister appointed.
Thank you for correcting that, but it's 50-50 again.
Our minister, our director
board,
composition?
Board composition.
Yes.
50-50 employers and union. Okay. What is being done to rectify this particular case, and is this a common occurrence, that is, employee is medically terminated whilst on workers' comp and Coal LSL are not informed by the employer or their insurer? This seems, by the way, very similar to the mistreatment of Mr Simon Turner by BHP and his employer at the time, a labour hire firm, Chandler McLeod. What's being done to resolve this, and is it common?
So the scenario of, we're talking termination, and I've tried to explain that in a couple of hearings over the years as well, but I'll appreciate there's a lot of new members. I'll explain the process again, and our GM Legal, Michael Dowser, might be able to add to the process. But the employer will advise us through their monthly levy returns a termination code for the employee. One of the reasons for termination can be for ill health. Others would be redundancy or cessation. So that process hasn't changed. That is the legislative arena that we operate within. So nothing has changed from the explanations over the years in regards to how do we collect the data, how does the employer advise us, and then how do we verify the data through the relationships and interactions with the employers.
So that was one of the problems that Cola LSL was encountering, lack of verification of the data. I'm not saying you didn't do this here, but so it's common then for someone's employment to be terminated but still be on workers' comp.
I can't talk to the commonality of that, Senator, in regards to the data, but as I said the reason for cessation will be advised to us from the employer.
But sometimes the employer won't tell you, won't notify you.
They will notify us of a reason of termination.
Yeah, but sometimes they won't notify you that he's actually been terminated.
Would you like to add to that, Michael?
Yes, Michael Dowser, General Manager of Legal. The notification comes through our levy form, and they identify when employment has ceased, the cessation code, which indicates the reason for termination. So that is a reporting from the employer. If subsequently there's an issue in relation to that, we'll engage with both the employee and the employer to seek to understand that issue. But ultimately, it's to be resolved between the employer and the employee.
Okay. So the question was: is it a common occurrence that an employee is medically terminated while on workers' comp and Cola LSL are not informed by the employer or the insurer?
What we are notified of is the cessation of the employment. There's no requirement to notify us in relation to any other details in the employment relationship.
Okay. So in your experience of checking up, it's not really common that you're not notified.
I think the way I'd answer that is in relation to complaints. So it hasn't come through. Your question is it a common occurrence? No, we don't have volumes of complaints which would illustrate a systemic issue in common occurrence of employers advising us of termination codes which an employee doesn't agree with. I know there are a couple of cases, and certainly we've had a lot of conversations around those, but I wouldn't say it's a systemic issue that has been understood through volumes of complaints for the scenarios that you're talking about.
What are the, and I'm not accusing you of governance issues at the moment, we've sorted them out hopefully after the review. What are the implications when this occurs? For example, an impact to levy payments because the employer no longer paying, super payments, internal workloads of Cola LSL to investigate and resolve such matters. Does it put a burden on you?
So the scenario that if it's found that an employer has advised us of a termination code that an employee disagrees with, certainly the resource from the team to engage with the employer, engage with the employee, assess information, etc., and if that is unresolved, then we would be advising the employee to take it to the Fair Work Commission because we'd be classifying it as an industrial relations dispute, which is out of our jurisdiction.
Okay. So if the companies fail to notify Cola LSL within a reasonable period, what would normally come of it? For example, 6-month failure to inform you, as in Mr. Joseph's case. Well, what happened there? 6 months BHP didn't inform you.
So I'll talk about the obligation under the Collection Act, Senator, that the employer has an obligation to submit a monthly levy return. So that is a statutory obligation. In regard to correcting or working through a disagreement or a dispute in information that we've received, that would be a process which isn't, I'll say, time-bound in our statutory frameworks, but the employer has an obligation to inform us monthly of employee service and any other critical information such as terminations, eligible wages.
So if this is proven to have occurred by a registered organisation, what intervention or penalty or enforcement would Coal LSL apply under its constitution to deter recurrence? Is there any?
The key obligation is to submit a monthly levy return with correct information. We are reliant on that information in terms of being able to conduct any further inquiries. If an issue is brought to our attention by an employee, we will engage with the employer and seek to get the employer and the employee to resolve that issue and communicate the outcome to us. We don't have any power to adjudicate on that dispute.
No consequences on the employer.
If there is an incorrect levy return, then there could be consequences, but that is a factual matter which we would not have evidence of.
Could you please advise why Mr Joseph's Coal LSL number looks to only exist from September 2022 onwards, as per his Coal LSL commencement letter recently provided to him under Freedom of Information? Why is the specific reason for the delay in creating his Coal LSL member number? Or what is it? What is the specific reason? Why was...
I think we'd have to take that one on notice, okay, Senator, and have a look at the time frame of his records and provide a response on that review.
Mr Joseph has been provided information under an FOI, Freedom of Information, that shows Coal LSL levies were paid by BHP to Coal LSL as early as July 2022. However, his welcome member letter was produced in September 2022. Why was that?
So we'll take that one on notice.
Is it possible for levies to be paid when an identification number does not yet exist?
Yeah.
The levy return, when the levy return identifies a new employee, we will take that information and effectively create a record for that employee. Our obligation is to keep records.
And then you get an identification number out of that.
And there is an identification number which will be created at that point at which the employee is first put on a levy return.
So it wouldn't be possible for levies to be paid when an identification number does not yet exist?
The first time that a new employee is properly identified on a levy return would be the point at which we would commence a record for that employee.
Yeah. Okay. Mr Joseph requested all company audits provided by BHP to Coal LSL for the entire period of his employment 2011 to 2024. I don't think he was continually employed at Mount Arthur for that period. I think he was involved in other divisions of the company, including Western Australia. Why was he only provided with 2 years, considering Coal LSL are reviewing his open recognition of prior service application for periods that fall within this Freedom of Information date range, 2011 to 2024?
Senator, can I take that one on notice as well? I do know the FOI case. I can't answer without going back to the reasoning as to why that information was provided and some wasn't, but I know that the team work within the jurisdictions of FOI, so we'll take that one on notice and provide a reasoning.
That's fine, Ms Burks. The December 2023 Coal LSL BHP external audit report indicates potential discrepancies in reimbursement amounts claimed by BHP. Has the investigation into this matter been completed? This is 2 years later. Has it been completed?
That's their audit report. I'd say, Senator, it's quite common through the receipt of or the process of that audit work for employers to have adjustments in reimbursement claims or levies. And it's through that audit process that the reimbursement, if it's overclaimed or overpaid, would be rectified, and similarly, the levy payment would be rectified. I won't answer without being able to check with the team that has been closed out, but I'd be very confident it has, with an audit report dated December 2023, that an action from the audit report submission would be closed out as our administrative processes
Perhaps you could take this next. Thank you. Perhaps you could take this next one on notice then. Was this in fact found to be a confirmed finding, that is, BHP claiming illegitimate reimbursements, and if so, how significant were the findings of this discrepancy?
Illegitimate, that's a strong word. What we do find with, again, if I take us back to the process of the employer, it is a self-reporting scheme. So the employers, through the submission of monthly levy returns and then the reimbursement claim process, we'll be calculating based on our guidance of how to calculate levy payments and also how to claim the reimbursement under the reimbursement rules. It is very common that employers get it wrong. It's a complex administrative process, so it is quite common that through the external audit function that we do rely on for the assurance of the correctness of levy paid and reimbursement claim, it is very common there'll be an adjustment. So I wouldn't typically classify that as illegitimate or deliberate actions. We would typically see that as human error on the employer's side, and then the audit process provides the assurance to then get the adjustments correct.
Is this a disclosable matter? And should it? And was it? If it is, was it disclosed in the Coal LSL annual report for financial year 23-24?
No, that's not a disclosable matter,
Okay.
Senator. As part of the no, it's not.
Thank you. Is it true that BHP did not pay any Coal LSL monthly levies from any of their owned entities to the Commonwealth Coal LSL Fund between the period of November 2015 to November 2016?
I would take that on notice, but I'd find that I would be very surprised to find that they hadn't paid levies. I would be very confident to say they have paid the levies, but we will take that on notice to answer your question.
Something in my mind reminding me of that might have been proven in the Iron Mountain document. Can you recall that? I can't.
The
Iron Mountain document.
I'm not familiar with that document.
And could you also tell me what was done about it, please?
If it wasn't paid?
Yes.
Yeah. Yes.
Was that approach consistent with the Coal LSL constitution at the time, and were any penalties applied? If you could tell us that as well, please.
If an employer hasn't paid levy in line with their obligations under the Collection Act, the levers that we have available is to charge an additional levy. It's an interest calculation. That is the lever that we'd have available to us.
Okay. So we have got some penalty provisions.
We do have some penalty provisions.
BHP and Coal Mines Insurance previously refused to acknowledge Mr Joseph as a black coal industry covered employee, challenging him on this as recently as July 2024. Yet Coal LSL have received levies from Mr Joseph since July 2022. Can you explain how and why this would occur from Coal LSL's perspective? I've got my thoughts on it.
Other than taking
look,
notice,
my position on that is for the purpose of compliance with our scheme, the inclusion of an employee on a levy return is a statement by the employee in relation to eligibility under our scheme. Matters relating to other issues of employment, we do not have visibility on and wouldn't have a view on.
Yeah. I'm guessing there's still probably some confusion. Mr Joseph was on a staff, what some people call staff payroll, which is an admin job or a managerial job or a supervisory job, compared with, say, a coal miner at the front line, which would be on a hourly rate.
I would make the distinction that coverage under any industrial arrangements is in some cases a different assessment to eligibility under our scheme. So it's really not appropriate for us to be commenting on those interpretation questions.
I'm just wondering if that's where some of the confusion comes from, because he wouldn't have been, being on the supervisory staff or administrative staff, he wouldn't have been on the Black Coal Mining Industry Award. He would have been staff award, for example. So, does the Coal LSL levy apply to the accident pay component of employee wages when on workers' compensation?
The issue of a employee on workers' compensation is dependent upon the nature of the workers' compensation arrangement with the employer and the employee. So, if the employee remains employed by the employer, then that is leviable eligible wages. If employment has ceased, then the obligation under our scheme is on the employer. There is no obligation on an insurer under our scheme, so there is no leviable eligible wages if employment has ceased.
So if the insurer is paying workers' compensation, but the employee has been terminated, there's no obligation on BHP?
That is correct.
And there's no obligation on the insurer to pay either? Is that what you're saying?
That is correct.
Thank you. Should an employee on workers' comp in the black coal mining industry who is medically terminated and who remains on workers' comp continue to accrue coal LSL leave if they remain incapacitated due to their injuries and condition whilst they continue receiving workers' compensation wages from their... You just answered that question. This gets complex, doesn't it?
How are you going?
Probably another 5 minutes. Well, maybe less, because we're getting to change topic pretty soon, and then it should go quickly. Considering Mr. Joseph currently remains on workers' comp... Now you've answered that question. In previous estimates, Department of Employment and Workplace Relations stated a list of around 80 entities who may have been paying levies in error. Has this investigation now concluded?
Paying levies in error?
Yeah. Remember that?
Yes. Yes, that investigation has concluded. It was 28 employers who were paying levy in error, and their levy, 25 of the 28 employers have been refunded that levy amount. The 3 remaining, for I'll say different reasons, still need to be transacted, and that's, we're waiting on the employer to provide information so that we can refund that amount.
So they overpaid?
They incorrectly paid into the scheme.
Too much, okay.
Yep.
Were any of the entities coal services or coal mine services? They wouldn't have been, would they? They don't employ coal miners.
No.
Does the list include any BHP-owned entities?
No.
Okay, change topics. You'll be pleased to know. Move on to the audit. The most recent audit report conducted by Australian National Accounting or Auditing Office, ANAO, of Coal LSL flagged their comments, their quote, higher risk related to both valuation of investments and the valuation of provision for reimbursements. What is the real meaning of these 2 findings of risk as regards the effective operations of and the integrity of the scheme? What are the risks and to whom are the risks against exposure?
Mr Wendever will answer that question.
Thank you, Senator. Tony Wendever, Chief Operating Officer. How are you? The external audit focuses on areas of higher risk on our balance sheet, and these particularly would be in areas of our provision for reimbursements, which is a piece of analysis that's conducted by our actuary, but also our investments, as you pointed out. But to be specific, they're around higher areas of risk of misstatement of our financial statements. So if I speak to the first one...
So no financial risk, just a risk of error in your statements?
In the financial statements, that's correct. So if we talk about the first one, the provision for reimbursements, that analysis is conducted by our actuary. It's considered to be an area of higher risk rather than a high risk for the organisation, in that the modelling and the estimations and the assumptions and judgments that go into that, just by its very nature, it's an inherent high risk area, and one that's a recurring area of higher risk, if you like, in our audit reports in previous times, so it's not a new finding for us. The second around investments is around the valuation of our unlisted trusts, and simply the reason why this continues to be a higher area of risk is because of the nature of those investments. Unlisted trusts are considered to be more complex from a valuation standpoint compared to other forms of assets. And certainly if you look at our portfolio, there's a portion of our portfolio that are illiquid assets, and they are also, from an auditing standpoint, more complex to assess from a valuation standpoint. So that's why the valuation for investments is also considered a high-risk area. And again, Senator, it's something that we've seen in previous audits. It's not a new set of findings for us.
So it doesn't affect the integrity of the scheme?
No,
it's got more to do with assessing the size of the investments, the rates of payout and the rates of income?
That's correct, Senator. So it's the accuracy, it's so that we can stand behind the accuracy of the financial statements. And again, these two areas are focused on our balance sheet in particular.
So you said there's no real risk to your entity, to Coal LSL?
That's correct.
So there's not going to be much fallout if the risks crystallise?
They're considered to be high-risk areas, but each year as we work through the audits, we had a successful passing again of this audit of our financial statement, so we're satisfied with that outcome.
So the funds I'll move on to the next part of this. The funds arrive in the accounts of the scheme from compulsory levies upon the relevant employers, right?
Correct.
The funds held by the fund are now in excess of $2 billion. What happens to the excess income generated from the scheme after leave entitlements are paid out?
You're correct about the size of the fund, Senator. It's $2.6 billion now. We measure the health of that in terms of a fund surplus or a fund coverage ratio. And that's how I'd answer that question, if you like. It remains on the balance sheet, but it's we have some goals that we work towards around the coverage of assets over our liabilities, and we manage to those goals accordingly. That's how I'd answer that one.
Okay, I'll come back to that in a minute. Not many more to go now, Chair. Emmett J. in the Federal Court in 1998 had emphasised there was a lack of control of the corporation. Now, I acknowledge that some years, 27 years ago. There was a lack of control of the corporation by the government and a lack of accountability to the government. Was it a government entity at that time, Coal LSL?
1998, yes, it was 1992 that the entity was established under the Administration Act.
Okay. What change in government, if any, has occurred within Coal LSL since then to tighten it up?
Since 1998? Senator, that's a very big question. So I can talk about what we've done, or since I've been in the organisation, and we've had a lot of conversations around that.
Governance, that was a particularly hot issue, yep.
Yep, I can talk to that specifically. Since 1998, I wouldn't answer that question.
Thank you. Perhaps I hear what you're saying. Perhaps given that the fund was originally set up as a stopgap measure to build up a money chest, if you like, to cover an estimated shortfall of funds to cover long service claims. Can your office comment on what purpose is satisfied for the fund to continue generating millions of dollars per year after the original purpose was met a quarter of a century ago? Why is it still continuing?
That's a very good policy question. I can talk with passion about the value of the scheme, and I'm the first one to talk about the value of portable long service leave and what it has done for the industry and employees in the industry. What I would say is...
Excuse me for cutting you off. I didn't mean that. You don't have to convince me of that portability. That's fine. What I'm getting to is that my understanding, I think it's correct, is that there was a fund created because there's a shortfall in funds. That now you've got a big, massive surplus in funds. Why is the fund still in existence?
That would be a question for government, but I do know, I think you're referring to the first reading speech or the explanatory memorandum in 1992, which talked about, why was the fund being created, and the payroll levy was set at 5% at that point of time to get the fund back into...
comfortable with all of that.
Yeah. So what I would say, though, it wasn't legislated. There was nothing in the legislation in 1992 that said that to legislate a winding up of the fund. It was, yes, it's in the first reading speech as... Oh, well, is it an intention? I won't comment, but definitely it's in the first reading speech, but that didn't translate into the legislation when the fund and the corporation was established.
Well, what I was getting to, Ms Perks, was that I'm not talking about the original coal mine insurance fund. I'm understanding, I'm a bit hazy on this, but I'm understanding that there was a stopgap measure of an increase in fund to cover a shortfall due to excessive payouts and not enough revenue coming in, probably one of the boom and bust years. So they instituted an additional levy as a temporary stopgap. It's now well past that, and they've got a massive $2.6 billion in funds. You don't need it anymore. Why is it still going?
Why is the fund still going?
The extra fund.
No, the additional payroll levy that you're talking about, no, that was removed in 2008 from memory. So the payroll levy was set, and then there was an additional component added, which made it to a levy of 5%, and that was in place from 1992 through to, I think it's 2005 from memory. When the fund got back into a neutral position, that's when that additional levy component was removed, and our levy has been at 2.7% for many years.
That's what I was getting at, not the original fund, the stopgap fund. So that has been removed.
Yes.
So this is wrong. Thank you. Thank you. Minister, a question for you. Why is a private company run by the New South Wales Minerals Council, the Queensland Resources Council, and the Mining and Energy Union, managing billions of dollars contributed compulsorily by employers on behalf of the federal government?
I'll have to take that on notice, Senator Roberts, and see what I can provide you.
Thank you. Before you came into the chair, a lot of the problems have come from entities in the coal sector, have come from entities that are 50% Minerals Council or 50% Minerals Council, Queensland Resources Council, and 50% Mining and Energy Union directors. And there seems to be a very tight cluster of organisations: Coal Mines Insurance, Coal LSL, Coal Services. There's another entity in there too that I've forgotten.
I think the Minister's taking that one later.
Yep. So I'm just trying to give her some background. That's it. Thank you very much.
Thank you, Senator. That concludes today's hearing. I'd like to thank all witnesses who appeared, Hansard Broadcasting and our Secretariat for their assistance. I remind senators that the committee has agreed that any written questions on notice should be lodged with the Secretariat by Friday, the 24th of October 2025. The committee stands adjourned.